if I enter like an oral motion of dismissal based on constitutional grounds, are you standing on your constitutional oath
I'm not sure what that is.
in regards to the right to travel under the 14th Amendment?
Okay, so that's not actually in the Constitution.
I just wanted to point out to the court that automobiles hadn't been invented when the 14th Amendment was ratified.
Buckle up, guys. Today we're diving straight into a case where chaos shows up long before the judge does. The host opens with a sharp setup, hinting that the courtroom is about to get messy thanks to one man who can't seem to help sabotaging himself. Even before we reach the legal drama, you can already feel the tension rising and the disaster warming up in the background next.
Mr. Gray, are you trying to get a driver's license?
Your Honor, I'm here by special appearance.
I knew that was coming. I knew that was coming. Let's just talk a little real simple, basic stuff. Are you trying to say that you can just run red lights, you can just speed, you can just do what you want to do on the roads without any repercussions at all?
Your Honor, is this a court of record? I'm sorry, is this a court of record?
As far as I checked, it was, Mr. Glenn.
Yes, it is, sir.
Preview rolls like a warning siren, showing exactly how wild this week is going to get. Judges shutting down sovereign citizens, a defendant arguing imaginary constitutional rights, and a self-proclaimed victim threatening lawsuits against the court. It's a rapid-fire montage of delusion, denial, and courtroom reality checks that sets the tone before the main case even begins.
So I will be countersuing Romulus, or I guess it would be Van Buren. And if the court proceeds with this, I will be also bringing the malicious prosecution against this court as well, because these are erroneous charges and they're retaliatory, which is a violation of my freedom of speech. It's a violation of my right to due process. So if this does not get dropped today and it moves forward, I will be filing under color of law lawsuits against Van Buren and this court for violation of rights under federal question jurisdiction. So I just don't think it would be a good use of the court's time or resources to continue this malicious prosecution. They completely ignored my evidence. There was sexual discrimination against me because I was a woman. It would really be a waste of the court.
The case officially opens. The tension shifts to real stakes. The friend of the court lays out a long trail of missed payments and repeated hearings, painting a picture of someone who has been given chance after chance. The courtroom tone turns serious fast as the judge and staff establish that this isn't a one-off. Mistake, this is a pattern that's finally closing in on the defendant. Nick.
Okay, we're on the record in McNamara versus Sylvester, case number 2018299. The record should reflect Mr. Sylvester has appeared today by Zoom video. We also have Mr. Brzezinski present on behalf of friend of the court. This is set for a show cause hearing today regarding support. And Mr. Brzezinski, can you give me an update on this case?
Yes, Your Honor. This hearing was adjourned from February 6th for the defendant to pay $200 plus stay in communication with the friend of the court if he did not have that ability to pay. He has a support obligation of $363. This is now, I believe, the sixth show cause hearing since June 22nd of 2022. The last payment was August of 2022 at $400. So most of these hearings have now resulted in payment. Multiple times the defendant has been ordered to provide job searches to a friend of the court, which he's done, but it has not resulted in him gaining employment or making any payments. So the friend of the court would ask if he does not have employment or any income, that he provide proof of that, whether it be unpaid bills, rent, proof that he's going to the interviews, just verification of all those details to prove that he truly does not have an ability to pay.
Well, I can tell you that my phones are currently shut off with a past due balance of almost $900, if that counts for anything. And I'm behind on my mortgage. That's $606 a month. Currently don't get a electric and gas bill because something's wrong with consumers. But I can tell you that we're behind in that too. There's only one income in this house, and there is a baby due next month as well. There should be a payment made. I just filed my taxes. I received my state taxes. I know you guys do with income withholding on that. So you guys should be getting a payment for my taxes. I was supposed to get $600 and some change, and I only received $238 back. So there should be a decent payment going to you guys out of my taxes.
Mr. Brzezinski, if the court proceeds with contempt proceedings at some point, would this be a first or subsequent finding?
I believe this would be a first finding of contempt, Your Honor.
Okay. All right. So I'm going to set this for a contempt hearing in April. Mr. Sylvester, there's a couple of things that you need to do under the law. And number one is to make your payments, of course.
Okay, well, I have absolutely zero.
Can you listen to me for a
No,
second?
I'm listening. You guys tell me this every
Defendant starts listing his struggles, hoping to prove he's not ignoring his obligations, but drowning beneath them. Shut off phones, overdue mortgage, and a baby on the way. All of it spills out in a frantic attempt to convince the court he's not withholding effort. It's a moment that shows the human side of the case, even as the pressure keeps building.
Well, don't use that kind of language. You're in a courtroom.
Okay, what are you going to do?
What am I going to do?
I don't come up there.
I'm going to hold you in contempt. I'm going to issue a bench warrant for you to be arrested. Do you want that to happen?
No, but you guys tell me this every time. I have 92 applications out on fucking Indeed right now. I can't help that I can't get a job.
Shift from desperate to self-destructive happens instantly. Instead of listening to the judge, the defendant snaps, interrupts, and fires off profanity that turns the room against him. The judge tries to hold the line with warnings, but each outburst pushes the situation closer to a legal cliff. It's the turning point where frustration becomes the thing that
Mr. Sylvester, based on your language, I've already warned you one time. If you use that language again, I will hold you in contempt.
Okay, well, as I was saying, I cannot help that I can't get a job. Okay, so I've had some places call me back, but it doesn't get me anywhere. I've had 2 interviews out of all of my applications. We've got 1 vehicle, one income. My insurance is actually almost expired because I can't pay that either. I don't know how I'm supposed to make payments when I don't have an income. I don't know how you want me to prove it, but I'll prove it.
Are you done?
Okay, I see where this is going.
Are you gonna listen, or are you?
Oh, I'm listening. I'm gonna get my shit transferred.
Despite the damage already done, the defendant tries to reel the moment back in with explanations about job interviews, insurance, and bills piling up. But the commentary makes it clear he's undoing his own case. Every attempt to justify himself is overshadowed by his earlier behavior, showing how badly he misread the courtroom and how fast he's burning through the judge's patience.
All right, you just used more inappropriate language. So I'm going to, based on your conduct here at this hearing today, I'm going to find you in contempt. I'm going to order that you serve 30 days in the Otsego County Jail for contempt in the view of the court. This is a summary proceeding, and that's based on your conduct here in front of the court.
I'll speak to a lawyer.
I'm going to issue a bench warrant for your arrest. You'll serve your 30 days here once you're arrested and brought before the court. I'm also going to set this for a contempt hearing in April. If you aren't employed and you can't make payments, you need to provide proof of that to the front of the court.
You guys don't tell me any way how.
Or bring proof of that to the hearing in April.
Okay, you guys want proof, but you guys right here, this is exactly what I'm.
Okay, I'm muting Mr. Sylvester now because I need to be able to make a record and he's talking over me.
Because you guys don't give me a chance.
I'm going to, I gave Mr.
This is where consequences hit. After repeated warnings and non-stop interruptions, the judge has no choice but to issue a finding of contempt. 30 days in jail is ordered on the spot, and the shift in the room is instant. It's the moment when all the tension pays off. The defendant's refusal to control himself becomes the very reason he loses his freedom.
Mr. Sylvester, I've given you more than an adequate opportunity to talk here today, and at some point you have to listen, and you're not doing that, so I'm muting you because I need to make a record. So if you don't provide that proof to the front of the court at the hearing in April, or bring it or provide it to the court for the hearing in April, then the court will issue or proceed with contempt proceedings, and you could be subject to a contempt penalty of up to 45 additional days. So Mr. Brzezinski, if you can set that for a hearing for contempt in April, I'm going to issue a bench warrant for the court's finding of direct contempt here on the record today, which is a separate issue that you don't need to deal with, Mr. Brzezinski.
Okay, thank you, Your Honor. I will do that.
Judge lays out the final terms with absolute clarity. Provide proof of income issues at the next hearing or face even harsher penalties. A bench warrant is issued, and the defendant's fate is sealed until he decides to cooperate. The video wraps with the host reminding viewers that this meltdown didn't have to happen. It was built entirely by the defendant's own choices. If you enjoyed this breakdown, make sure to like the video, subscribe to the channel, and we'll see you in the next one.